Abhishek Singhvi. Mr. Singhvi.
Sir, I don't know how much interest is left in this debate as we wind it up and all of you are keen to get home, but I was struck by the fact that it's the most unusual debate. It's most unusual in both the content of the debate, in its sequence, in its outcome. Because it's a debate whose outcome is known, we all support the motion, the terms of reference are known, the result of the motion is known, the government is in fact proposing what the opposition wants, most of the members of the proposed committee are known, the sequence is over and yet we are debating it. So it's truly an unusual debate in Parliament, and perhaps that is why it has lost its edge. In a sense, it is a debate which is almost infructuous before it starts. But at another level, because it is so predictable, it can be a debate which should lead to calmer consideration, somewhat more objective and clinical thinking. And as I come at the very end almost, I propose to deal briefly with three broad issues, because I believe, sir, with great respect to a lot of the preceding speakers, that this is a debate about the forum which will debate in future the merits of the case. This is not a debate about 2G. It should not be allowed to become a debate about 2G. And it is not a debate about the merits. Let me complete. Let me complete.
Please, Javadekar ji, आप बैठिए.
I know that when you have a weak case, you resort to interruptions. I thought most of the interruption brigade had left the house. Some people are still here. Please listen to me calmly. The minister's statement stands on a different.
Manu Singhviji's name was there in the motion.
It was not there.
As a member, when this was circulated, his name was there. I am told that he withdrew his name, saying that he represented some company, that's why he don't want to participate in JPC. So now, when he don't want to participate in the formation of JPC or in JPC proceeding, how can he participate in the motion?
If I can respond. First of all, my good friend Mr. Ahluwalia has raised a point because he doesn't want to advise those members of his party who really have a conflict of interest not to do so. So he is accusing a person who at the outset, as a senior counsel with no personal conflict of interest, decided to opt out of the JPC without advising his own party members. He is now objecting to me participating in a debate. I don't think I recused myself from Rajya Sabha. I don't think I recused myself from this debate. I recused myself because I thought it fit, unlike unfortunately Mr. Ahluwalia, some of your members, to disclose at the outset that years ago, and as several eminent lawyers sitting in the house on your side and our side know, as a senior counsel you never really have a conflict of interest because you don't represent a client. But several years ago, in several different situations, I have appeared for all sides, including in particular companies which have attacked viciously the decisions taken by Messrs. Mahajan, Messrs. Paswan and Arun Shuri, purely as a counsel. So I disclosed it so that there would be no delay and no intended or unintended conflict of interest in the remotest sense. If from there you extrapolate to prohibit me or prevent me from speaking in a debate about a motion to appoint a JPC, I think there is no sequitur, there is no connection between your objection and what is happening here. But since you are so conscious, yes,
then only you can participate in the debate. You have not declared earlier.
No,
now you declare it. Then only you can participate.
I have said there is no direct conflict of interest, personal or otherwise.
Direct
I
or
appeared
indirect?
as a senior counsel for different telecom companies in the early 2000s, challenging policies and implementation in the Supreme Court and the High Court. So for a JPC that might not be necessary, but certainly please leave it to my good conscience as to whether I can speak in a debate or not. And I think those who know a little bit more about law and our President in this House will realize that there is not the slightest conflict of interest in my speaking. But since you are so conscious about conflict of interest, I would only advise you or request you to consider that about some people who have real conflict of interest, whose decision is written on the file, whose decision on the file is coming for scrutiny by your committee, by your joint parliamentary committee. I leave it to your good conscience and that of your party to decide what to advise them, instead of giving me unsolicited advice, which with great respect is irrelevant to my case. Sir, may I therefore go on and say that there is absolutely, this is a motion about constitution of the JPC. It is not a motion about the merits of what the JPC will or should consider or what the outcome of those merits will be. Because otherwise you are reducing this House to a JPC here and now. And in fact, it was our earliest proposal that the best place to discuss all this is the House. The JPC is in that sense an inadequate representation of this House. It has some 7 or 8 parties out of 37 odd parties. And it would be quite nice if you all agree to discuss it in the House even for a week or 2 weeks. It is you who decided to go to a JPC. Therefore, I think it's not necessary to go into the merits of the dispute. The minister's statement always stands on a different footing. He introduces the subject, he is entitled to make a statement. But the rest of the House need not decide or adjudge the merits of what the JPC will in due course decide. Let me, sir, with your permission, deal with 2 or 3 broad issues relating to the topic, the motion. I think, as I said, it's a strange debate, because having agreed now to what the opposition wants, I am going to say 3 things. First, justify as to what was the rationale for us not to want a JPC or not to agree to a JPC earlier. Please don't get me wrong, the idea is not to say there should not be a JPC. Now we've all agreed that chapter is over. In that sense, the whole debate is infructuous. But I am now trying to explain very briefly why you did not, or why we rightly thought that a JPC was unnecessary. The second thing I think which should concern us in this debate is that despite us rightly thinking that a JPC is not necessary, we moved heaven and earth at every stage to show the greatest flexibility, made several offers and counter offers, because it was we, unfortunately not you, who were interested in parliamentary democracy. And it is that which ultimately led to this motion being moved today.
What can I say? This is not unparliamentary and all that.
Why should you object to the content of my speech? But sir, the third aspect is the most important, since the first 2 aspects are behind us. The third aspect I wish to draw your kind attention to is that this whole episode, our earlier stand and our current stand and where we are going in the future, has great lessons for parliamentary democracy. And I think this debate would be valid and justified if for nothing else, since large parts of it are infructuous, if for nothing else, if we decide to learn some of those lessons of parliamentary democracy. Now, sir, on the first issue, the leader of the opposition talked about the fact that this is not a case of mere arrests or punitive. It is about policy for which the JPC is most appropriate. Let us look a little more closely. Let us first see what the JPC could not do, because this was a JPC demand a few months ago in the midst of very unusual circumstances where a lot of action had already started. Multiple actions in multiple fora were underway. As far as I can recollect, none of the earlier 4 JPCs had multiple actions of multiple kinds in multiple fora already underway. That is a major qualitative difference. Therefore, what was underway, and could the JPC...
When JPC was constituted, they were in jail.
Alwala sir, permit me. Please permit me.
CBI and Enforcement Directorate started their investigation.
The CBI investigation can ultimately and has in many cases led to arrests. It has punitive consequences. It can take you to a criminal court of law. It can prosecute you. We all accept the JPC cannot do it. The income tax investigation can have huge monetary penalties. The JPC cannot and does not intend to do so. The Enforcement Directorate can have forms of both monetary and coercive punitive penalties. The JPC cannot. The The Shivraj Patil Committee report has looked at a whole range of irregularities and covers both the intra-departmental, inter-ministerial, etc., all aspects. The JPC can also do it, but it's been comprehensively done. Now the policy aspect is covered by two fora. The PAC would be able to analyze every paragraph of the CAG report. And I started, Mr. Prashad, you are not here when I started by saying, you are not here. You are not here. You are not here.
As if when you talk, they will have to listen. When they talk, you have to listen. There is no.
You are not here when I started by saying. There is no
shortcut.
That the formation of a JPC is a fait accompli. But it is nevertheless my duty to explain and justify why we took a stand which we did. And if that is a distinction you cannot understand, I cannot help it. The policy aspects, you are following the same principle of interrupting me as on television channels and out-shouting me. That is only a sign of a weak case. That is the only sign of a weak case. Now, the reason policy is covered largely is because the PAC looks at every aspect of a policy. I don't think any major or even a minor aspect of policy has escaped the CAG's attention. And which part of policy of the CAG would not be covered by the PAC is for you to consider. So policy is certainly available to a parliamentary committee headed by an eminent member of your party, who has in fact at one time said, before you stopped him from saying so, that he has jurisdiction to go into all aspects. You wisely stopped him from repeating that statement too many times. Then there is also, of course, the parliament itself. Why could you not have had a full session of parliament? Indeed, as today you have started a debate, many of the speakers have addressed on the merits. A full parliament session could have discussed these very issues. So our objection was in that sense a principled objection based upon what was already happening. Multiple actions, multiple fora, which leads me to my second point. There was a genuine feeling that sometimes your demands were more political reasons, more for keeping the pot boiling, perhaps even unintendedly obstructing and delaying other proceedings by going to the JPC. The JPC in the earlier 4 avatars hasn't had that great or glorious a record of actual implementation of decisions. Let us be frank, in all the earlier 4 avatars, what has been the major fundamental change, coercive, punitive, policy or otherwise? Yes, a JPC is a great hallmark of parliamentary democracy, but what is its concrete result in our country is a question which has to be kept in mind in terms of precedents which have happened. In a case where so many actions were going on, and knowing the past record of JPCs in our country, I think it was a legitimate viewpoint of the government to consider that this is not a priority area, and it is certainly not so much of a priority area as to justify the obstruction of parliament. Before I come to the third and the most important aspect of this debate, which is the lessons for the future, I would like to beg of this House to consider that look at the conduct. When this whole debate started from October, November, and you put your foot down about not letting Parliament function, who showed the maximum flexibility? As the opposition, you opposed everything, but did you propose anything? You proposed nothing. It was we who proposed a whole special session of Parliament. It was we who proposed a multidisciplinary investigative agency to be attached to the PSC. It is we who opposed that the PSC proposed that the PSC can be empowered in every which way, and ultimately it is we who agreed to the JPC, who has shown more flexibility, more sensitivity to parliamentary democracy. You may not like the fact that you are accused of subverting parliamentary democracy, but at every stage it is this government, at every stage At every stage, it is we who have shown great sensitivity and flexibility down to moving this resolution. Sir, अब आपको जितना समझ आ रहा है उतना आप समझें, मैं तो अपनी बात कहना चाहूंगा. Sir, the lessons for the future are important. Today, you obstructed Parliament on the ground of the JPC. Let us assume that there are 2, 3, 4 other issues which arise in this session on which we agree to disagree violently and totally. Maybe there is something in some state, maybe there is some comment, maybe there are serious allegations against a member of the ruling party or the opposition. And we agree to disagree seriously and vehemently. As a matter of principle, is this House to accept the principle that disagreement, howsoever violent and vicious, can justify the disruption, the absolute non-functioning of Parliament? That is an issue which you have to consider. You have no reason.
Javadekar ji,
Please.
See, वो जो
You have no reason.
See, whatever he says, he is not asking any answer from you. Please, he has his right to whatever he wants to say within these rules.
In fact, I would be surprised.
If he yields,
Of course, of parliamentary democracy.
if he yields,
Parliamentary democracy. Please
if he
consider.
yields,
Please, parliamentary democracy is 2 words. You reduce it to half by negating Parliament. Parliamentary democracy is not mere democracy, it is democracy through Parliament. And in constitutional law and otherwise, countries which stop the total functioning of Parliament in law are supposed to be akin to martial law. If you don't like it, you should not disrupt Parliament. You should not disrupt Parliament.
please, Pani ji,
Yes.
Mr.
Continue.
रविशंकर प्रसाद जी,
That is
आप
why-
उनको बोलने दीजिए, प्लीज
That is-
प्लीज प्लीज.
That is why.
You are Mr.
That
Ravi.
is why. That is why.
आप बैठिए, पानी जी बैठिए. अरे आप बैठिए ना,
That is why.
आप भी बोले वो भी बोलते, बैठिए
That is.
बैठिए प्लीज.
That is why Parliament. That is why emergency powers in the Constitution contain and consist of provisions for extension of Parliament. It is considered an emergency, not normally. Who did it? You need not have
Please.
those who disrupt Parliament must bear the cross for it, must carry the cross for it. Why did you disrupt Parliament? We
Please,
totally reject.
nothing will go on record except Mr.
We
Mehta.
totally reject the principle that on any ground of adamancy, on any ground of disagreement, on any ground of obstinacy, it does not justify the stoppage of Parliament. That's the precise principle. Please assume that you do not agree with anything. You can wear black bands, you can shout slogans outside, you can attend partially, but you cannot and should not stop the functioning of Parliament is the basic principle. It's the basic principle. And today,
क्या बात है भाई? अरे उनकी बात वो कर रहे हैं, क्या अनपार्लियामेंट्री क्या है? अरे वो जावड़ेकर जी, आप बैठिए, आप बैठिए, आप बोलिए. Nothing will go on record except Mr. Singhvi. Mr. Pani, this is not correct. Don't interrupt.
उस वक्त आपने संसद को अवरुद्ध किया. अब आप मेरे वक्तव्य को अवरुद्ध करना चाह रहे हैं. ये अवरुद्ध करने की राजनीति छोड़ दीजिए, कृपया छोड़ दीजिए. अपनी बात कही आपने, हमने बिना झिझक के, बिना इंटरप्शन के सुना. हमारी बात सुन लीजिए. मैं सिर्फ ये कहना चाहता हूं कि अगर इस विचार विमर्श का सबसे बड़ी सार्थकता अगर है, सबसे बड़ी सार्थकता है तो ये है सार्थकता कि ये सोचें कि क्या किसी कारण से, किसी भी कारण से आप संसद को पूरी तरह से अवरुद्ध करने का हक रखते हैं, सही करते हैं। सैद्धांतिक रूप से क्या एक पार्लियामेंट्री डेमोक्रेसी में ये किया जा सकता है? अगर आप इसको सैद्धांतिक रूप से इस सिद्धांत के लिए मान लेंगे तो कल किसी भी कारण से ये वापस दोहराया जा सकता है। ये गलत है और ये गलत हुआ है, और इस गलत को जानना, इस सिद्धांत को आत्मसात करना आवश्यक है भविष्य के लिए कम से कम। इसका मतलब ये नहीं है कि किसी प्रकार से जेपीसी नहीं हो रही है या ये रेजोल्यूशन पारित नहीं किया जा रहा है। इसका मतलब ये नहीं है कि हम साथ मिलकर आगे भविष्य के लिए जेपीसी को सकारात्मक न बनाएं, लेकिन इसका मतलब निश्चित रूप से यह है कि आगे के लिए अगर आप इस सिद्धांत को नहीं मानेंगे या हम नहीं मानेंगे, तो अगर हम कभी भी बाद में कोई भी पार्टी विपक्ष पे होगी तो यह सिद्धांत बहुत खतरनाक है, पार्लियामेंट्री डेमोक्रेसी के लिए खतरनाक है। लेकिन दुर्भाग्य की बात है कि इस सिद्धांत को आप अभी भी नहीं मान रहे हैं। इसलिए अगर आपको आगे बढ़ना है सकारात्मक रूप से, तो यह भी मानिए कि पहले गलतियां हुई हैं और वो गलतियां आपसे हुई। बहुत धन्यवाद।